Legal Talk with Robin Bond, the show where we break down the complex world of law and make it work for you. I'm your host, Robin Bond, and today we're diving into one of the most powerful tools in estate planning, trusts. Now, my wheelhouse is the world of work, and we all work very hard and we save and we hope to create not only better lives for ourselves, but often for our heirs, what we call the concept of generational wealth. So this concept of worth ties into today's discussions. I recently published an article that you can read on my website and in Mainline Today magazine called Fighting for Your Worth After a Sudden Termination. This usually happens when an executive loses a high-paying job without warning. And beyond that emotional impact, there's also a very significant financial impact, usually in terms of value left on the table, like equity and long-term incentives that can disappear the moment that you're escorted out the door. But there may be more leverage here than you think. In almost every instance, the company from which you are departing will insist on you signing some sort of a separation agreement and release of claims to get paid any severance pay or benefits. And they would like you to depart quietly and not subject the company to the scrutiny of either administrative investigations or lawsuits. So this does give you power and leverage for negotiations, regardless of the facts of your matter. I'm going through this right now in several instances where the value offered for shares was not adequate. So you have to go back and negotiate for what you think is fair market value. So before you sign anything, have your employment attorney review the separation offer documents and make sure you aren't leaving money on the table or signing away important rights without adequate consideration. Now, if you want to read more specific tips on what to do and read about lawsuits where executives have fought these matters and won, particularly like Twitter and Elon Musk, I write about that, where the Musk fired his top executives within one day of taking over X, and they were owed hundreds of millions of dollars for that. It's very interesting litigation. You can get more information on that in the news section of my website. So we just can't talk about it today, although it would be very interesting. So let's just say you do get that equity and wow, it's yours now. Now you can worry about what happens to those hard-earned assets after you're gone. Are they going to end up in the right hands? Are they going to create that generational wealth that you want? Or are they going to be eaten up by taxes or a lengthy court process that's going to delay your family's financial security? So if you've ever wondered about these things, then today is the episode for you. I'm joined today by attorney David Frees. David heads the Trust Estates and Wealth Preservation section of the Westchester, Pennsylvania law firm that he co-founded, Unruh, Turner, Burke, and Frees. He also co-chairs the elder law section. He's a frequent speaker in the areas of trusts and estates, and he's been awarded the designation of Pennsylvania super lawyer and mainline top lawyer. So welcome, David. Thank you for joining us.
Robin, thank you for having me here.
And as a good way to dive into this topic, we have a viewer's question, and I'm going to ask David to respond to it. So if we could put it on the screen, please. Okay, the question is here. How many times should you change your will to keep up with changes in estate laws? David?
Yes, happy to answer that. And it's a great question. There's not a bright line answer for that because there's two things going on. One is what changes are taking place in the law that might individually or cumulatively affect you. And the other is what changes are going on in your personal life. So, for example, you might have a child that was married and got divorced. You might have a child that passed away where money is now dropping down to a grandchild, and that might cause you to re-examine your estate planning. As a general rule of thumb, major life changes, you're canceling a significant life insurance policy that was part of your estate plan. You're getting married or divorced, or someone in the family who's inheriting is going through a change like that. Those should trigger you to go in no matter how long it's been. If it's been a month, you should go back and talk to the lawyers that did the work for you. But as a general rule of thumb, when people call us to come back and redo their wills, when they call us 2 or 3 years later, most of the time we're able to say, no, this particular change was anticipated. There haven't been that many changes in the law. You're good. You can still continue to use your existing documents. That changes by about 5 to 7 years. Almost everybody benefits from coming back in to update their plans. The other good thing to do if you're working with a firm on this, just ask them to send you a newsletter or updates where you can see changes in the law that might trigger you to want to update. So it's a great question. Thanks.
Well, thank you so much. That was a great answer. It's time to update my wills, obviously. So hey, here's how you can submit your questions to Legal Talk with Robin Bond.
You can have your questions answered on Money Matters. Please go to our website, money-matterstv.com. On our homepage, click on the banner on the right that says, Send us your questions. While you're on our website, you can find information about our host and guests, as well as show notes and links about this show and past shows. Money Matters is also available as a podcast on iTunes and Stitcher, so you can listen to Money Matters while you're on the go. That website address, again, is money, M-O-N-E-Y, -matters, M-A-T-T-E-R-S, TV.com.
So trusts just aren't for the ultra wealthy. I mean, I think for some time we thought that might be the case, but they're really a very smart, flexible legal tool that anyone can use to protect their assets. The use of trust is really about future-proofing your estate plan and protecting your children and your grandchildren, like David was saying, from divorce, lawsuits, creditors, changing circumstances. But many people aren't sure if they need trusts, and they fear maybe it will be inflexible and tie up their money. So David is going to walk us through today how modern trusts help us craft smarter, more flexible trusts. So whether you're just thinking about your estate or you're ready to take action, I think this is one conversation that could make a real difference for your family's future. So David, I'd like to start with sort of a foundational question here, is when should you think about using a trust? For example, what are the main reasons to use them?
Sure. So trusts come in many forms. Sometimes people use them and create them during their lifetime to either make gifts to children or grandchildren and to protect those gifts. Sometimes they use them to avoid probate. But even if you're just doing a will and relatively simple estate planning, you should ask your lawyer about using what are called testamentary trusts, so that if you pass away, the trust is in your will to protect the inheritance of a child, grandchild, or even a spouse that might remarry.
Okay, that's great. And then, so what are some of the common misconceptions, though, about trusts? Because, like I said earlier, some people think of them as these ironclad, inflexible documents that maybe aren't going to suit their needs in the future. So, what are some common misconceptions that we can dispel here?
Yeah, there are a number of them. And to your point, it was true that when trust law developed, trusts were designed and often were administered by a large bank or trust company without input from the beneficiary or family members. And they were rather rigid, and as laws changed through time, hard to adjust. But in the modern type of trust we draft now, we can use trust protectors and other systems provided for under the law to be able to modify trust when circumstances change. There are other misconceptions too. So I guess the first one is that trusts are not necessarily rigid or difficult in the way that people sometimes thought they were, because they're referring to experiences that a family member had decades ago. One of the other misconceptions is that if you set up a trust and you put your assets into it, you could protect it from your creditor's claims or a divorce. And that's not always true. The types of trusts that can protect you or your heirs from losing inherited assets in a divorce or a lawsuit from a car accident or something like that, those have to be very special types of trusts. So I think people think, I'll just get a sample trust and I'll use that. But there might be income tax consequences to that and others. So
please do not buy forms off the internet, right?
Exactly.
Oh my gosh, that's the worst thing that's ever happened. Hey, but you mentioned something about a trust protector, and I think we really need to talk about that concept. So tell us, what is a trust protector? What do they do, and why are they becoming so common today?
Yes, we've used trust protectors for many decades, but they were very uncommon even 20 years ago. It's a new role. So it isn't the trustee. The trustee is the person who is managing the money and the assets within the trust for a beneficiary. And the beneficiary is the person that gets the use of the assets or the benefits of the asset. And we always have traditionally had co-trustees too. So often you could have a family member and an institutional trustee, like a bank or trust company, that combine to administer the trust for the benefit of a child or a grandchild. The trust protector is a new role, and they come in many different shapes and sizes, but their job is to make sure that if the trustee is not doing their job or not doing it in a way that's consistent with the trust or the intent of the person that created it, that they can fix that. They can fire a trustee and hire a trustee. If the law changes so the trust doesn't do what it's supposed to, they can often make changes without having to go to court, which can be very expensive. Most people want to avoid the probate court and avoid the probate court looking at their trusts, and the trust protector can do that.
Well, who is this person? Is it like my son is the trust protector, my lawyer, my bank? I mean, who is the trust protector?
Yeah, these are great questions.
Maybe.
Yep. So if you're creating a trust during your lifetime, you probably can and would name the trust protector. Whether it can be a family member or not is a question of the particular goals of the trust. Sometimes we can't have a family member there, and it's better to have a neutral party. That could be a lawyer, it could be an accountant, it could be a trusted family friend. It can be more than one person too. You can have a committee. So sometimes trust protectors are granted the power to veto certain kinds of transactions where you have very large amount of wealth in a family business. So the decision about who should serve as the trust protector is a really important one. And you spend, in my experience, a lot of time on that. Now, if you're doing it in your will, you may leave it up to the trust beneficiaries and the trustees to pick a trust protector in the future that meets all the requirements of the trust.
Oh, gosh. And what happens, David, because sometimes I have heard about this where, a beneficiary of a trust is married and the spouse pressures them to take funds that they're getting, which would normally just go to the beneficiary, and use them to purchase an asset that would be held in joint name. So I guess that would then transfer part ownership of those trust funds to the spouse. So how would the trust protector protect the beneficiary in an instance like that? Or what would happen?
Yeah, that's something that anybody that wants to protect their children and grandchildren from losing an inheritance in a divorce should think about. If we leave our assets directly to our child or grandchild because we think they're adults and capable of managing it, there's a lot of psychological pressure if they're married to put those assets into joint names. And in that case, if the marriage were to dissolve, you could lose them. If they go into the right kind of trust, then they can be protected. And a trust protector and a trustee can give children and grandchildren guidance. Should I take the money out and buy a house with my spouse? Should I borrow the money from the trust? Should I buy the house within the trust? These are all things that the trust, if it's well drafted and designed to protect against divorce and lawsuits and possible failure of a business, the trust should be flexible enough to allow for those choices. And a lot of times we'll make the trust more protective. If a child has been through a divorce, we will maybe not build as much flexibility in as we would otherwise. And then sometimes we build the trusts so that the child has a great deal of control over it, but still gets the divorce and creditor protection.
That's great. And can you just clarify again, what is the difference between the trustee and the trust protector? Is the trust protector sort of an overseer of the trustee, or what is the difference?
Yeah, that's a good way to think of it. The trustee is the person who has what they call a fiduciary duty to the trust beneficiary. They're supposed to be taking care of the money, looking at the trust and giving money out, or as it's required to be given out under the terms of the trust, and making sure that it's properly invested with somebody that's a knowledgeable investor and properly diversified. The trust protector, on the other hand, is overseeing it to make sure that the purposes are carried out, that the trust can be adapted without having to go to court, that the right trustees are in place, and that there could be modifications. So for example, in your example, if the protections are rather minor and interest income is going out, and the divorce shakes up, it might be something where the trust protector could turn that off. So the trustee's obligation is to give the money out the way the trust says, but the trust protector might have the power to turn it off and give it a higher level of protection if a divorce actually occurs.
I see. So why weren't these trust protectors used in the past? I mean, what has changed that now we do use them or can use them?
Yeah, so our trust law, for the most part in the United States, comes from English common law. And English common law was designed in a patriarchal system to really give the person that created the trust an enormous amount of control and often limit the control of the beneficiaries in the future. And also the pace of change in tax law and in trust and estates law was much slower. In the last 20 years, the pace of change of income tax law, federal estate and gift tax law, state laws that impact these trusts, they change all the time. And so we took a concept from asset protection trusts that was commonly used maybe 30, 40 years ago, which was the trust protector. And we started to build that into domestic estate planning. So we took a technique used by very, very wealthy people, and we found ways to give modestly affluent people and their families the benefit of this kind of flexibility. But it's really been more commonly used only in the last 10 years. I mean, we've been drafting these kinds of trusts for a very long time, but you see it cropping up more and more.
Wow. I know several people that have to do special needs trusts for children that, will outlive them but have special needs. Could you use a trust protector for that kind of a trust?
You could, and where you might commonly see a trust protector used is if the special needs child's needs are pretty well defined and we kind of know how they'll change through time. The trusts are usually pretty well drafted to adapt for that. But state laws on benefits could change, and the trust as it existed might disqualify the person. The trust protector could usually fix those kind of things to carry without having to go to court. And going to court exposes families' private matters to public scrutiny, and it's expensive. So a trust protector can often do things for hundreds of dollars or a few $1,000s that could cost tens of thousands of dollars or more and result in public scrutiny of a very private trust.
I really want to emphasize that point because people with the special needs children often say, well, if I set up a trust, I may deny this child the access to certain government benefits, right? But you're suggesting that if you have a trust protector and the government benefits could be in jeopardy, perhaps the trust protector could step in and rectify the situation so the child could still remain eligible for these things.
Yeah, I mean, that's a great thing for anyone watching this. Have that discussion, whether it's a special needs trust or not. Have a discussion with the lawyer about what the purpose of the trust is, the underlying sort of philosophy about it. Have some memos maybe off to the side that describe how you view the importance of the intergenerational goals and whatnot. And that way, if the trust does need to be modified in court, which we hope to avoid, there's some documents that can help people do that, but it also gives the trustee and the trust protector guidance if they're doing the fix without court supervision.
Yeah, and you mentioned that going to court is really expensive and inefficient. So I don't know why that is. Maybe you could tell, why is it, and then what kind of changes can this trust protector make to keep us out of court?
Sure. So I think the why is a complicated one, but basically, as people have lived longer and have often depleted more of their assets, children's expectations, regardless of how you feel about that, have not been met. They thought they were going to get an inheritance when they were much younger. They thought it was going to be much bigger. And so there is a lot of fighting and litigation that goes on. And that means that those courts have their resources strained. And so anytime we can do planning in a way that keeps us out of that court system and has mechanisms, for example, there's even questions now about how aggressive should we be in drafting alternative dispute and mediation requirements into wills so that we keep people from fighting in court. But the courts are busy, and hiring lawyers to go into court, there's very few people that do that sort of work in court, and it's supply and demand. So if there are fewer lawyers and lots more demand, they can raise their fees. So
higher billable charges. You had mentioned that the changing tax laws, because I know there have been some changes in how IRAs get taxed. So if in fact the tax laws and the state laws continue to change, as often they do, administration to administration, how does that trust protector help the trust adapt to these changing tax laws?
So without using a confusing example, I'll talk about the Secure Act. So IRAs, most of your viewers and listeners probably know, IRAs were taxed one way up until 2021. And then the government said, oh, if you leave one of these accounts to your children, they've got to withdraw the money within 10 years. That's an oversimplification. But it meant that the type of IRA trusts we used in people's trusts and wills no longer worked the way they were supposed to. And so in those cases where we had a trust protector, they could go in and modify or fix the trust without having to go to court to have the court approve that. There are also laws that allow the beneficiaries and other heirs to get together and agree to certain kinds of changes. But I always like to make it as easy as possible for the right kinds of changes to be made. So we don't want to make changes in who gets what when, because that's generally speaking what the person that set up the trust wanted to control. But we do want to make changes that the trust can comply with new laws, new tax laws, or new regulations.
Yeah. So if the trust was drafted like 20 years ago, and then today's tax laws make it outdated or inefficient, what does the trust protector do? Or what do they
So
do?
that trust may have a trust protector, and then it's easy to fix it. Or to your point, they may not have a trust protector because it's quite old and it might be more rigid. And we have some new laws in Pennsylvania, relatively new, that allow heirs to get together and to voluntarily make changes in an existing irrevocable trust or a trust under a will. And one of the things that I would do is I would consider modifying that trust to allow for a trust protector so that future changes don't necessarily have to be approved by the court then.
Oh, that's great. Yeah, I can see that too. And, like if you have these trust protectors, and what happens if you have a beneficiary that gets remarried? How does that affect the potential redirection of family wealth? And does the trust protector have a role there?
Yeah. So a lot of clients come to us and we ask them, do you want to try to protect this inheritance you're leaving to your kids from divorce, lawsuits, possible failure or bankruptcy of a business? And they go, yeah, I didn't know I could do that. So you can create a trust like that, and you could create a trust that gives very liberal access to a child with the money and still protect it, and build in the ability of a trust protector to modify that. So if a child were to get divorced, if that divorce started, the trust protector with the trustee might be able to change the trust or turn down the distributions and let them build up within the trust until the divorce is finalized. These laws, you have to watch it, and you want to get advice, from your own attorney based on your particular facts, because how judges look at these trusts and think about them changes through time. But you can absolutely build trusts that offer a fairly high level of protection. I would simply add that if you're worried about a child getting married and divorced, that a prenuptial agreement and a trust offer much better protection than just the trust or just the prenuptial agreement alone.
Absolutely. I'm a big believer in prenuptial agreements. Yes. Because, the other thing too is a lot of people want to protect their grandchildren.
Mm-hmm.
And make sure their grandchildren get something. So how does this trust protector help preserve this multi-generational wealth that, I started our show today by talking about, I'd like to have generational wealth for my grandchildren.
Mm-hmm.
How does the trust protector help us do that?
When you're planning, and people have heard of generation skipping trusts, a lot of times they think that's just they're skipping right down to the grandchildren. But you can set up a trust that benefits a child, and then when that child passes away, it goes to your grandchildren. But obviously, and on, obviously those trusts could go on for 50, 100 years, giving those children and grandchildren divorce and creditor protection, but giving them access to the money. The thing is that in that 50 to 100 years, so much could change. The needs of the child, the needs of the grandchildren, the nature of how trust assets should be invested based on those needs. And both a trustee and trust protector can, again, work together. The other thing that's nice is that the trust protector can fill vacancies if there is a vacancy of the trustee, a trustee dies, they could fix that. And the trust protector and or the trustee can often move the trust from one jurisdiction to another. So if you died in Pennsylvania, where we're talking today, but your grandchild or great-grandchild lived in South Dakota, where there were better trusts and tax laws, they might be able to move that trust from Pennsylvania, where it was controlled by Pennsylvania law, to Delaware or South Dakota, where a different state's law would control. So it really gives a lot of flexibility for these long-term trusts.
That's huge. I know, because oftentimes it's like, well, which jurisdiction should we, be using here? Should you have a certain level of wealth before you use a trust? Is there?
Yeah, that is a great question. I would say maybe more than a specific level of wealth would be how much you're leaving to each child or beneficiary. So for example, if a person has $1 million and they're leaving that to 5 children, that might not warrant a sophisticated trust. The costs of having the trust might outstrip the benefits. But if that same person has $1 million or 2 and only one child who has a disability of some kind or another, then the trust is 100% going to be used there. And then there are all those circumstances in between. But we also see trusts that go on for a lifetime of children to give them this kind of protection rather than terminating when they're young. Because if you have a trust for your child or grandchild until they're 21 and then the trust stops, they're getting that money and then it can be taken away from them in a divorce or lawsuit.
Yeah.
The longer term trust, we start to see people using after they have a net worth of a few $1 million.
Okay, thank you. Well, these were all really great tips. And I think, it does reinforce again the need to get good professional advice, because there's so many options out there. And like, we just wouldn't know all these things that we've talked on today. And I get the sense we've just sort of scratched the surface. So David, thank you so much for joining us and sharing.
Thank you very much.
It's been very, very helpful. We really appreciate it. Thank you. I hope you all join us again next month when we're going to dive into real estate legal matters. I love watching HGTV with all the house flippers and stuff. And I thought, well, let's do a show on that. How do you be a house flipper? How do you buy properties at tax liens and sheriff sales, and what are the legal pitfalls that you need to know about? So I hope you will join us next month, April 1st, when we do the exciting world of house flipping and real estate. So thank you again, and take care until we see you next month.